Hello. So, guys, can you hear me and can you see me? Just give me a heads up if you can. Good evening. Good evening, guys. Can you hear me? Good evening. So, today we are going to discuss the Companies Act and okay. So, we'll try to finish off the chapter today itself. Okay, we'll try to finish off the whole chapter today itself. It's a very small chapter anyway. So, Companies Act. When I say company, what exactly do I mean by a company? So, if I look at this definition, it says company means a company incorporated under this act or any other previous law, right? Means a company incorporated under this act or any other previous law. This act means what? Companies Act. Previous company law means any company law before Companies Act. So this Companies Act came into force in 2013. So if let's say I'm incorporated under the 1956 Act, will I be considered as a company? Yes. Now what are the characteristics of a company? So when we say company, first and foremost, obviously it's a voluntary association. Two or more persons, seven or more persons come together. Two or more persons, seven or more persons come together and to start this business, right? Two or more or seven or more people come together to start this business. I think now it's audible, right? Like, wait. Now is it good? Guys, please tell me now is it good, okay? Okay. So, when I look at this definition, I get the characteristics. First and foremost, it's a voluntary. Voluntary means, association means people coming together. No, now if it is low, Pranav, you must check your side, okay? Must be something your end. When I say, oh my God, when I say voluntary, it means we are doing it by choice. When we say voluntary, means we are doing it by choice. Now, separate legal entity. The most important characteristics of a company is actually separate legal entity. Now, when I say separate legal entity, the moment a company is incorporated, as between the members and the company, a thin wheel called the corporate wheel comes into existence. I cannot touch this wheel. I cannot see this wheel. It's intangible, but it distinguishes the company from its members. That means the company and members are not liable for each other's act. The company and members are not liable for each other's act. This concept was laid down in the case of Solomon versus Solomon, where the question raised before the court was that when the entire family members are also the members of the company and also the part of management of the company, is it that the family and the company is different? Yes, the court held yes. Even if the company is managed by only the family members, all the family members are managing the company, still the company and members are different, they are not the same. The second question that was raised in the case of Lee versus Lee Air Farming Limited was that if the company is managed, if can a person be both the employer and employee of a company at the same time? It was held in this case that yes, a person can be a employer and employee at the same time, because a company is a separate legal entity, and even if you are the owner of the company, you can still be the employee in the case of a company. The next one was the property, the liability. The liability of a member is limited. The moment a company is incorporated, the liability of the member is limited to the unpaid value of the shares held by them. So if let's say my value of the shares is rupees 10, of which rupees 6 is paid up, maximum liability that the company can ask me to give, or the maximum money company can ask me to give, is 4 rupees per share into the number of shares. And the day I have paid that 4 rupees also, my liability is now 0. The day I have paid off that 4 rupees also, my liability is what? 0. Death, if you remember, in partnership, death of a partner results in the death of the firm. Even if 10 partners are there, one is dead, it's over. But here in case of a company, even if all the members are dead, right? Even if all the members are dead, still the company exists. So I repeat again, in case of a company, even if all the members die, the company's existence remains unaffected, the company will continue. Even if all the members die, the company will continue. The next one, moving to the next one, transferability. In fact, there was a very interesting case that a company had a private company had 5 members, all the members were dead. Even if all the members were dead, the company's existence is different and the company shall continue. इसके बाद में transferability of shares. In case of private company, I can still put restrictions. In public company, shares are freely transferable. I cannot put any restrictions to transferability of shares. In case of partnership, transferability of shares is not that easy. I need the consent of all. But here it's freely transferable. Then the next one is the company has a right to own and hold property in its own name. When I say property, property can be both movable and immovable, and property can be both tangible and intangible. Whether tangible, intangible, whether movable, immovable. Company can continue to hold the property in its own name. In fact, there was a very important concept which was laid down in the case of Makora versus Northern Assurance Company Limited. The member took an insurance of the property of the company in his own name. The court held that why would the member take the insurance in his own name? The company, property belongs to the company, only company has a right to take the insurance. The insurance company refused to pay. Can they refuse to pay? Yes. Next, capacity to sue. The member, if a company wants to sue a third party, or a third party wants to sue the company, they can sue the company in its own name. They don't need the name of the members to file a case against the company. Then it is managed by a separate body called the board of directors, singularly called the directors. But one thing is there, these board of directors are actually appointed by the shareholders only. And the last one, earlier it was mandatory for a company to have a common seal, but as of today, it's not mandatory for a company to have a common seal. So if the company has a common seal, then in that case, the common seal will be used. But if the company does not have a common seal, the document shall be signed by 2 directors, or if the company has appointed a company secretary, 1 company secretary's signature has to be there and 1 board of directors. With this, we are done with the characteristics. So what the corporate wheel says is company and members are different. However, in certain cases, the court ignored this wheel. The wheel was lifted. And when I say the wheel was lifted, the company and member was taken as one. The first case, protection of revenue. Sir Dinshaw Manik Ji Petit. There was an Indian case, Juggilal versus Income Tax Commissioner, on the same grounds. So D had formed 4 companies, and to each of the companies he had transferred a block of his investment. Whatever income was earned by this companies from this investment was given to D as a loan, which was never repaid. The court held that the only purpose that these 4 companies were formed was to dilute the holdings and to avoid payment of higher taxes. The court lifted the wheel. And when I say the court lifted the wheel, that means what? D was asked to pay the higher taxes. Please don't write court lifted the wheel and member was taken as one. I want to know what would be the verdict given in that case. The next one, prevention, where the company is made for improper or conduct or fraud. So the name of the case was Jones versus Lipman. A had made a contract with B to sell his land to B. But in the meantime, C offered a higher price and A did not want to sell the land to B. So what he did was he formed, to avoid the sale of land, he formed a company and sold the land to the company. When B asked him to sell the land, he was like, sorry bro, I don't have the land, how can I sell it to you? He goes to the court. So when he goes to the court lifted the wheel and the court said that the only reason this company was formed was to avoid the sale of land. The wheel was lifted. And when I say the wheel was lifted, it means what? A and company was taken as one. A and company was taken as one to determine the true character of the company. Actually we'll come to this in the last. The next one is where the company is a sham. The name of the case was Guilford Motor Company versus Horn. What happened in this case was G had hired H as his employee. Soon he became so famous with his clients that everyone wanted to deal with H only. So G made a contract with H that till you are working for me, fine. Once you quit my job, you cannot deal with my clients. G agreed, H agreed. But the moment my employee comes to know that he is important, he is crucial, he has that ego. So H also thought, I am irreplaceable. So what H did was, he left the job. But after he left the job, he realized that he only knows G's clients and he only knows how to be a mechanic. So what H did was, he formed a company and through this company, he started dealing with G's clients. He formed a company and this company started dealing with G's clients. Then obviously G got very irritated. He was like, how dare he do this? So what G did was he filed a case against H. H said, are you mad? I am not dealing, company is dealing. You don't know separate legal entity. The court said, Ruk ja bachcha, don't go into the separate legal entity. Don't be over smart. The wheel was lifted. When the wheel was lifted, that means what? The company declared that, court declared that this company cannot deal with G's clients. Correct? Cannot deal with G's clients. Is it clear to all of you? The next one, where the company is formed to avoid welfare legislations. Where the company is formed to avoid welfare legislation. What is this? Avoid welfare legislation. So see, there are some laws which are for the benefit of a sector or community or a society. When the laws are formed to, I repeat again, when the laws are formed to avoid these benefits or to avoid the giving of these benefits to that sector, the wheel can be lifted. When the company is formed to avoid these benefits, the wheel can be lifted. This company was there. See, there was a bonus act is there. The concept of bonus act is if you earn profit, you give bonus. If you earn high profit, you give high bonus. This company was doing very good and the MD was a very decent guy. He was like, I'm getting money because of my employees, I'll give them money. He used to give them money. But then what happened? This company had saved a lot of money. And because this company was earning, had invested, because they had a lot of profits, they invested. Obviously, investments mean income. Income means high profit means high bonus. Now the MD was like, I am saving the money and I'm earning. Why should I give that? So what he did was he formed a subsidiary company. This subsidiary company was doing nothing other than holding that investment for the company. Now the employees did not like, they filed a case. The court held that the only reason the subsidiary company was formed was to avoid the payment of higher bonus. The wheel was lifted. The wheel was lifted means the company was told to calculate the profit including the income from the investment transferred to subsidiary company and asked to pay the higher bonus. Next is when the company is acting as an agent or trustee of the shareholders. The name of the case was FG Films Limited. So this American company, they had financed a movie in India by the name of British company. It was actually majority of the shareholders were what? American company. The president of the American company held 90% of the shares. But they financed it in the name of in the name that they are British company, and they wanted to enlist the movie as a British movie. The court held in this case, even though it was a British company, it was the majority of the shares were held by the American company. So you cannot enlist this company as a British movie. It will be enlisted as a American movie. And the last one, in this case, the company had, in all the cases we saw companies doing something wrong. But here, the company has not done anything wrong, but the wheel was lifted. The name of the case was Daimler Company Limited versus Continental Tire and Rubber Company Limited. What happened in this case was this company was incorporated in England. Obviously, if you are incorporated in England, you will be called an English company. This was during World War. English and Germans were at war. So we are alien enemies of each other. So this English company filed a case against its English debtors because they did not pay. So the court asked the debtors, why are you not paying? You don't have the money? The debtors were like, no sir, we have the money. Then why are you not paying? Sir, if you tell us to pay, we will pay. But if we pay, we are funding our enemy. He was like, how? Sir, 90% of the shareholders of this company are German. Now see, doesn't matter whether you are a German, whether your shareholders are German or not. You are incorporated in England, you will be considered as an English company. But because of the delicate situation, because of the war going on at that time, because of the delicate situation, the court lifted the wheel and saw that 90% of the shareholders were German. And since at that point the Germans were enemy, the company was declared to be a German company, and so the debtors were asked not to pay. With this, we are done with this portion. Now, before I go to the types of company, which happens to be the next topic, if anyone wants to ask me anything, you first do that, then we will go forward. I did not understand. What happened, Soumya? Chalo, we'll go to the next part now then. Yes? I was planning to do some writing, some questions. Not all. I'll take up some 5, 7, 8 questions and do a writing session. So I wanted you to tell me which chapter you want first. With this kind of, we are done with the revisions, right? We are left with only 1 or 2 chapters, one unit 1 and negotiable. So which writing sessions we should do, which chapter? You just give me your suggestions on that, okay? So types of company. Broadly, remember every company is either a private company or a public company, and each of this company Soumya, don't look at anything right now. Keep doing your job. That's it. Don't be scared. You have put in so much of efforts. Everything will be good. And remember, harder the paper, easier the checking. Don't forget that. So don't worry on that. Okay, I'll do that. Chalo, can we go forward? Now, types of companies. Every company is either a private or a public company, and each of the company is either limited by shares or limited by guarantee or unlimited liability company, right? So moving on to the types of company. Moving on to the types of company. Yeah, you have put in so much of hard work. Right, it will be easy. It will be easy. Most welcome. Company limited by shares. I am only liable to pay. I am only liable to pay the unpaid value on the shares. The unpaid value on the shares that I am holding. That means what? Let's say I have rupees 10 ka shares. I've already paid rupees 6. Rupees 4 is my liability. I have to pay whenever company makes a call. Company can make a call during the course of business, or company can make a call during the winding up. During the course of business, BOD will make the call. During winding up, official liquidators will make the call. That's it. What is limited by guarantee? Here there is a specific amount that a member, there is a specific amount that a member promises to pay. Undertake means what? Promises to pay. But this money will be paid up only when the company goes into winding up. When I say limited by guarantee, it can be with share capital or it can be without share capital. If it is with share capital, we have double liability. First, unpaid value. Second, guarantee amount. Unpaid value, again double liability during the course of business, during winding up. Whereas guarantee amount only during winding up. If it is without share capital, I have a single liability only for the guarantee amount, and this money can be called up only during winding up. Unlimited liability company, there is no limit on the liability of its member, not having any limit on the liability of the members. But please remember, when I say unlimited liability company, please remember one thing: my liability is unlimited towards the company, not towards the creditors. So company can sue me for unlimited liability, creditors cannot sue me for the unlimited liability, right? Moving on to the next one, on the basis of number of members, OPC, which has only one person as its member. Only a natural person who is an Indian citizen, whether resident in India or otherwise. Please, I have told you, I have issued a video on this corrigendum which was issued by ICAI. 120 days is not mandatory, which was the law. If you remember in the class, I showed you also the mistake in the book. We had discussed that also, remember? So, when I say natural person, yes. Indian citizen, yes. Resident in India, no. That means even an NRI can invest in the securities of, can invest in the OPC, right? Shall be eligible to incorporate, that is to be a member or to be a nominee. What is the purpose of nominee? Tomorrow if anything happens to the member, the nominee shall take up his place. So the memorandum shall indicate, and resident in India means who has stayed in India for at least 120 days during the immediately preceding financial year. Then ma'am, why have they defined it if not needed? Definition is given, no? Because might be somewhere else application is there. Here it is not, but they have to define the term resident, no? Now the memorandum will indicate the name of the nominee, and tomorrow if anything happens to the member, death, incapacity, the nominee shall become the member of the company. And then nominee will give a written consent, and this written consent will be filed with the registrar. He will give a written consent and it will be filed with the registrar, right? Can the nominee withdraw his nomination? Yes, a nominee can take back his nomination. Can a member cancel or change the nomination? Yes, a member may remove the nominee and appoint someone else. So nominee may be given a right to withdraw his consent. The member may at any time change the name of such other person, right? Now, how many companies can you be a member and nominee? A person can be a member of one OPC and the said person, that means I can be a member of one and at the same time a nominee of another, but only one. That means I can be a member of one OPC and a nominee of one other OPC, that's it, but not more than one. Now let's say I am a nominee of another OPC and the member of that OPC is Swaha. So now I am a member of this OPC also, that OPC also. What will happen? If a person becomes a member of more than one OPC by virtue of nomination, he must within 180 days fulfill the requirements of the act. That means within 180 days, you must come back to one OPC. So, a natural person can be a member of only one OPC, and at the same time, the said person shall not be a nominee of more than one OPC. That is only one. If a person becomes a member in another OPC only because of nomination, it's possible. Within 180 days, he must meet the eligibility criteria. That means come back to one OPC. Ma'am, what should he do with the other OPC? That's his choice. Who are we to decide? Can a minor become a member? No. Ma'am, nominee to he can be, no. Member, nominee, nothing he can be. Kuch nahi. Can it be a Section 8 company? No, it can never be originally incorporated or future converted into a Section 8 company. Never. But it can convert into a private or a public company. It can convert into a private or a public company. That is possible, private or public company. And it cannot carry on the work of an NBFC. That means it cannot carry the business of an NBFC, including, that means it cannot invest in the securities of any body corporate. The word is not shares, the word is securities. Broadly, securities means what? Both shares and debentures. And body corporate means company plus company incorporated outside India. Clear to all of you? Yes. Now, the next one, private company. Private company means one which has a minimum paid up capital as may be prescribed. Earlier, there was a requirement of 1 lakh and 5 lakh for private and public companies respectively, but now that's removed. They say as may be prescribed. As of today, nothing has been prescribed, and by its articles. So, the articles of every private company will have these restrictions. First, restricts the rights to transfer the shares. We cannot say you cannot transfer your shares, right? I cannot say you cannot transfer your shares, but I can put conditions. I can put conditions subject to which, right? I cannot say you cannot transfer, but I can put conditions subject to which you can transfer the shares. Except in the case of OPC, that means OPC is a private company, right? Except in the case of OPC, limits the number of members to 200. Limits the number of members. That means it cannot have more than 200 members, up to 200. That's it. Provided that if there are joint holders, they will be counted as one. So when you're counting 200, you will count them as one. Again, persons who are in the employment of the company, that means I'm simply talking about employees. Persons who having been formally in the employment of the company, I'm talking about ex-employees. But you cannot only write ex-employees. Don't forget the rest of the part. Have acquired the shares while in that employment and continue to be the member after the employment ceases. So please understand, very important. You were an employee from this period. Okay? Let's say you have acquired the shares here. Will you be counted? Yes. You have acquired the shares here. Will you be counted? No. You have acquired the shares here. Will you be counted? Yes. You have acquired the shares here. You continue to hold them here. You sell them here, you acquire them here again. Will you be counted? Yes. From here to here, you will not. From here to here, you will not be counted. But from here, you will be counted. I hope it's clear. There are two questions on this. Please, Jagannath and that one P limited something, Prafulla limited something. Do try to solve those questions. Those two questions gives you a complete clarity on this. Prohibits. Prohibits means what? Disallowed. Not allowed. You cannot do this. Not allowed. You just cannot do this. Prohibits the invitation to the public. That means you cannot invite the public to take up the securities. That means neither shares nor debentures. You cannot issue anything to the public. Right? With this, we are done with private. Moving on to the public one. What is public company, which is not a private company? I've always told you, sounds very funny, but it means the restrictions of a private company are not applicable here. That is what it means. Has a minimum paid up share capital as may be prescribed. Abhi tak nothing has been prescribed, right? Provided that a company which is a subsidiary of a company not being a private company, that means what? Public. That means if a company is a subsidiary of a public company, X Limited, Y Private Limited. Y Private Limited is a subsidiary of X Limited. That means it's a subsidiary of a public company, not a private company. That means in that case, Y Private Limited is deemed to be a deemed to be a public. In its articles, it is still a private company. But those provisions of Companies Act which do not apply to a private company will apply on this company. Okay? Now, the next one on the basis of size. Small company means any company other than a public company. That means very clearly only a private company can get the status of a small company. That means when I talk about private company, OPC and small companies are also private companies, right? Small company के लिए your paid up share capital should not exceed. Please guys, हमने notes में लिखा था, if you are writing 50 lakhs, you have to write this notification. Let it be Y2. Cut this notification. Don't write this notification. Directly write paid up capital does not exceed 4 crore and turnover does not exceed what? 2. Nahi. Oh, sorry. I'm so sorry. 40 crores. Right? So paid up capital does not exceed 4 crores. Turnover as per PL of the immediately preceding financial year does not exceed 40 crores. If it is less or equal, it's small. If it is more, it's not a small company. However, this clause will not apply to a holding subsidiary company, Section 8 company or a company governed by special act. Very high probability you will get a question from OPC because of the corrigendum. Now, on the basis of control, X Limited, let's say ZOPC Limited, okay? Can X Limited hold shares in ZOPC Private Limited? Okay, I want an answer from all of you. Are you sure it's no? The question was, can X Limited hold shares in ZOPC Private Limited? The question was, can X Limited hold? Okay. So see, first of all, it's an OPC. It will have only one member, not more than one. And that one person will only be, yes, a natural person. Be careful. Exam where something like this comes, you should be very careful. And that one also has to be a natural person, right? That one has to be a natural. Yes, absolutely correct, guys. Very nice. You all deserve a pat on the back. I was expecting you will say, yes, yes, yes. This is using your intelligence. If you use this in the exam, you will not miss out what the question says. So you all deserve a pat on the back from me. Each of you, please take a pat on the back from me. For all of you, take it from me. Okay? Please do it from my side. Okay? So what is holding company? I have told you, if you remember, the relation of holding and subsidiary is linked with each other. If I am your holding, you are my subsidiary, right? Like that. And this is very clear from the definition. That means in relation to one or more company means a company of which such companies are subsidiary. That means I am your holding if you are my subsidiary. Subsidiary company means what? A company is said to be the subsidiary of another in which the holding company. So who will control the composition of the board of directors? The holding. Who will hold more than one half of the total voting power? Holding. Controls the composition of the board of directors. What do I mean by control the composition of the board of directors? The right to appoint or remove the majority of the directors. Right? The right to appoint or remove the majority of the directors. Exercises or controls. Exercises direct, controls through subsidiary. More than one half of the total voting power. That is, if I hold more than one half of the total voting power. I can hold it directly, I can hold it through my subsidiary, I can hold it together with my subsidiary. Right? In any case, I become holding subsidiary. Be careful, this is one of the favorite topics of the institute. Small company, OPC, holding subsidiary, they ask a lot of times. So be careful with these. Try to solve the few questions that are there on these questions on this. Okay? Associate company. A company is said to be the associate of another if such other has a significant influence over it. So let's say there are two companies, company 1 and company 2. Company 1 has a significant influence over company 2. Okay? Company 1 has a significant influence over company 2. Tell me which is associate, company 1 or company 2? Please, people get confused. In fact, in the ICI book also once or twice I've seen wrong answers. Be careful. I am controlling you. How can I be your associate? The one who is being controlled is the associate. No, guys. So, company 2 is the associate of company 1. Yes, be careful. Yes, exactly. Exactly. However, it has been held that shares held in fiduciary capacity, right? Shares held in fiduciary capacity. No, how can both of them be associate? One will be the associate of another. Then it won't be a circular relation. Huh? So, one's held in, so not being a subsidiary, that means up to from 20 to 50 you are associate, more than 50 you become subsidiary, right? Shares held in fiduciary capacity shall not be counted. So if you are holding the shares as a trustee, those shareholding will not be counted for 20% or 50% or more than 50. Government company. What happened, Pranav? All good? Should I explain it again? In which the government, the central government or the state government or both of them together hold 51% or more of the paid up capital. Okay, in this, no, here Be very careful. I've said government, not government company. We don't take government company ka holding. We are only talking about government. And again, if you are a subsidiary of a government company, includes a company which is a subsidiary company of a government. If you are a subsidiary of a government company, obviously you are a government company, right? So you become a government company in two ways. Either government holds or you are a subsidiary of a government company. Foreign company which is incorporated, obviously incorporated outside India, but has a place of business in India, right? You have a place of business in India, right? It can be either through an agent or it can be directly, it can be physical or it can be online, and conducts any business activity in India in any other manner, right? Now, on the basis of availability of capital, listed, unlisted. Listed means any company whose securities are listed at the stock exchange. Unlisted means any unlisted company. I have a question. Can a government company be a private or a public company? Okay. Please remember, it can be both. A government company can be a private or a public company. Okay. Now tell me, a non-profit company, can it be a private company or it can be a public company? Okay. Can be both. Okay. It can be both. So please understand, doesn't matter, you're a private, you're a Section 8 company, you're a government company, you're a holding, subsidiary, associate. Doesn't matter what type of company you are, you can be both private and public company. Okay? Now, non-profit company, they are formed to promote sports, science, arts, religion, charity, commerce, technology, environment. They do not distribute dividend. Is it that they cannot or they should not or they may not? They cannot. They cannot. So what do they do with the profits they earn? They reinvest the profits into the business to promote the object. That means they reinvest the profits into the business for the promotion of the objects for which they are made. Now, if the central government, you have to apply to the central government that I want to become a Section 8 company, and if it is satisfied, will issue a license. On the issue of such license, you become a Section 8 company. When you become a Section 8 company, you need not use the word limited or private limited on after your name, and even a partnership firm can be a member of your company. Now, if this company wants to alter its MOA or AOA, can it do so? Yes, but it needs the approval of the central government. Now, if this company acts against public interest or if this company breaches its objects, right? Or breaches its objects, or this is here it's profit. Surplus comes in the end. Surplus is surplus in winding up. Okay? Or it breaches its objects, or it acts fraudulently, or it breaches the condition subject to which the license is issued. In that case, the central government can revoke the license. And once the license is revoked, three things can happen. Either convert into a private or a public company. If you convert, you must use the word limited or private limited after the name and inform the registrar so that he can make the change. Second, you may be ordered to amalgamate with another Section 8 company with similar objects. Third, the company may be wound up. The surplus in winding up will be transferred to any other Section 8 company, or it will be transferred to it will be transferred to any other Section 8 company, or it will be transferred to insolvency and bankruptcy fund under the insolvency and bankruptcy code. But because amalgamation and winding up is a very grave step, it can be done only in the public interest. But before passing any order, the company must be given an opportunity of being heard. Finally, moving on to the other types of companies, dormant company, which is formed for a future project or to hold an asset or intellectual property and has no significant accounting transaction. What's an inactive company? Which has not been carrying on any business or operations for the past 2 years, which has not filed its annual returns or financial statement, or for the past 2 years, which has not, I repeat again, for the past 2 years, which has not had any significant accounting transactions. Right? What is significant accounting transaction other than this 4? These 4 are not considered as significant accounting transaction. Anything other than this 4 is significant. Payment of fees to the registrar, any payment to fulfill the requirements of this act or any other act, any allotment of shares because of the act says, like subscribers to the MOA, they have to take up the shares. So allotting shares to them. And payment for maintenance of office and records. Public financial institution, LIC, IDFC, Infrastructure Development Finance Company, Unit Trust of India, or any other companies notified by central government. Either they are established or constituted under any central or state act, or not less than 51% of the paid up share capital is held either by the central government or the state government or both. With this, we are done with the types of company. You have any doubts in it, you will first ask me and only then we'll move forward. And guys, I repeat again, this here we will write profits only in Section 8 company. Please, as he was telling, Pranav was telling, the surplus is only in winding up. Here we write profits only. This is not surplus. In fact, I had taken a test for you all. Many of you had written surplus here. Here it's profit. Surplus is in winding up. Right? Surplus is in winding up. Should I explain any of the types of company with an example? Should I explain any of the types of company with an example? Should I explain any of the types of company with an example? Nothing? Chalo. But please do try to, solve a few of the questions of this chapter on types of company. Moving forward, incorporation of the company. So first of all, promoter. Who is a promoter? Who is a promoter? First, you become a promoter in 3 ways. They have not defined, but they have given us ways to recognize a promoter. First, they say if you are named as a promoter in the prospectus of the company or annual return, you become a promoter. Second, you have a control over the affairs of the company. How can you have a control over the affairs of the company? Because you are a shareholder or because you are a director? Or as per your guidance, the board is accustomed to work. The board works only as per your guidance. In any of these 3 cases, you become a promoter. But remember, if the board is accustomed to work as per your directions, if the board is accustomed to work as per your direction just because you're a professional and you're guiding the company in a professional capacity, then you will not be considered as a promoter, guys. Then you will not be considered as a promoter. Be careful of that, okay? Then you are not a promoter. Now, incorporation of company. A company can be formed for any lawful purpose by 7 or more persons to 1 person by subscribing their names to the MOA, right? And this company can be limited by shares, limited by guarantee or whatever. For incorporation, I have to give an application in Spice Plus. Spice Plus, you have 4 applications you make. Application for name, application for incorporation, appointment of directors, and allotment of DIN. So these are the 4 applications that you make in Spice Plus, right? These are the 4 applications that you make in Spice Plus. Now, moving forward, along with the Spice Plus, right? Along with the Spice Plus, I will have to give 1 document, 2 declarations, 3 details. 1 document, MOA, AOA, 2 declaration. First declaration is given by the professional CA, CS, CMA or advocate in practice who is engaged with the formation of the company, and by every promoter, by any director, manager or secretary that we have fulfilled the requirements of the Act. The second declaration is given by every director and subscriber. What? That we are not guilty of offense in the incorporation of any company. We have not committed any breach or fraud in the management of any company, and all information given is true to my knowledge. This. Third is 3 details. First is details of address of correspondence, details of subscribers, name, surname, family name, address, occupation, photo ID, and if it's a body corporate, SIN. Details of directors, same, but instead of SIN, here it's a DIN. And the last one, details of interest of director in any other firm or body corporate and his consent to act as a director. All this will be given to the ROC. The ROC will issue a certificate of incorporation and allot a SIN. Certificate of incorporation will be under his hand and under his seal, that is under his signature and seal, and shall be the evidence that the company has been incorporated, right? He will issue a certificate of incorporation and allot a SIN. If you are formed by incorporating false information, and we come to know about the false information before company is incorporated, then every person who is aware of the false information liable under section 447. If I come to know after the incorporation, then every person who has signed, promoter, person named as first directors and persons making the declaration, even the professionals, liable under section 447. And tribunal can pass any of the orders against the company. What orders? Orders for the management of the company. What orders? Orders for the management of the company. The liability can make the liability of the members what? Unlimited. Removal of name, strike off name of the company, order for winding up of the company, and any other order it deems fit. But before any order is passed, the company shall be given a reasonable opportunity of being heard, and it will take into consideration the transactions already made by the company. Is it clear to everyone? Once company is registered, what will happen? A body corporate comes into existence. It shall have the same name as is given in the certificate. Subscribers to the memorandum and all the other persons who take up the shares from time to time will become the members of the company. It can exercise all the functions. It will have perpetual succession. It can acquire, hold and dispose of property, tangible, intangible, movable, immovable. It can make contracts, and it has a capacity to sue and be sued. Right? From the date given in the certificate, the date of incorporation mentioned in the certificate, the company becomes a legal person. Just because one company holds all the shares of another company, it does not put an end to the corporate structure of the other company. Right? Now, memorandum and articles. What is the effect of memorandum and articles? What is the effect of memorandum and articles? Guys, let's take 2 minutes break. We'll continue after 2 minutes. Okay? And here we are back. Are you there, guys? Sirf me back or you back also? Hello, 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 hello. Can we go forward? Chalo, moving forward. What is the effect of MOA and AOA? It is like as if we have individually signed a contract. So whatever is given in the MOA and AOA is as if it's signed by the company and each of the members. Whatever is there in the MOA binds the company to the members, binds the members to the company, but not members inter se. That is not members to each other. It will bind whatever is given, binds the company towards the members, binds the members towards the company, but does not bind the members to each other. Okay? Now, what is MOA? MOA means as originally framed and altered from time to time. It is basically the charter of the company, defines the reason the company is formed, and it's positively, it defines and confines the scope of the company, tells us what the company can or cannot do. The purpose is to the outsiders, it helps them know what the company can or cannot do. To the shareholders, helps them to know the money that they have given, the company is utilizing that money where. Now, what are the clauses of MOA? The clauses are 6 clauses: name clause, registered office clause, object clause, liability clause, capital clause, and subscription clause. Name clause is the name of the company, which always ends with the words limited or private limited. But if you are a Section 8 company or you are a government company, you don't have to use the word limited or private limited after the name. Second clause is registered office clause, states where the office of the company is situated. You generally give the name of the state. Object clause tells us the purpose for which the company is made and any matter considered necessary for the furtherance of the main object. Then liability clause tells us the liability of the member. It is limited and limited by shares, unpaid value of the shares, or limited by guarantee, amount of guarantee, unlimited, whatever. Capital clause tells us what is the total amount of capital that the company can raise and the division. You can just don't give the capital, you also give the division. Subscription clause is basically the subscribers. They give a declaration that yes, we are forming this company. They basically give this declaration that yes, we are forming this company. That's the subscription clause. They give a declaration that yes, we are forming this company. Along with that, their name, address, occupation, number of shares, their DIN or PAN, and their digital signature. All of it is there. If you are a one-person company, apart from this, you will also have the name of the nominee. So in case of one-person company, there are 7 clauses, the last one being the nomination clause. It must be printed, divided into paragraphs. Each paragraph should be numbered and it must be signed. 7 members in case of public, 2 in case of private, 1 in case of OPC. Okay. Now, moving forward, the formats is given in table A, B, C, D, E. Limited by shares, limited by... Who will sign? Let's say, if a company is a member of another company, it cannot sign because it's an artificial person. It will sign through its agent, right? It will sign through its agent. Minor cannot be a signatory because a minor has no contractual capacity. If the guardian of a minor signs, it will be deemed that he has signed in his personal capacity. That means if the guardian of a minor signs on behalf of the minor, it is the guardian who is liable to pay the money of the shares or whatever. Okay? Table A, B, C, D, E gives us the format. Articles, section 2 clause 5 defines articles as articles originally framed and altered from time to time. That means whenever you alter the articles or the memorandum, the altered copy becomes the articles or the memorandum. That is what it means. Now coming to the major part. Under section 399, memorandum and articles become a public document, and every person entering into a contract with the company is deemed to have knowledge about it. This is known as what? Doctrine of constructive notice. Moving forward, doctrine of ultra vires. You have the object clause. When you do anything which is within the object clause, it's intra vires, it's valid. If you do anything against the object clause, it's ultra vires. Ultra means against, vires means powers, and it's void. This concept was laid down in the case of Ashbury Railway Company versus Ritchie. Your papa tells you, you can take 500, you take two 500. That one second 500 is ultra vires. The one 500 is intra vires, the second 500 is ultra vires. Now, in Ashbury Railway Company versus Ritchie, the company was not allowed to give a loan, but they agreed to give a loan to Ritchie. The court held such an agreement is void ab initio. Now, what are the repercussions or what are the consequences? First, it's void ab initio. Both the parties cannot sue each other. Even the whole shareholders, all the shareholders cannot ratify it. Even a single shareholder can sue the company for injunction. If it is ultra vires, the directors, intra vires, the shareholders can ratify it. Now, key points, listen very carefully. If a company has taken an ultra vires loan, the other party cannot sue the company to recover the loan. If company has purchased any goods or services or used any loan to purchase any goods or services, which is ultra vires, the person has taken a loan which is ultra vires and purchased goods or services. The other person cannot recover the money. However, if the company has taken an ultra vires loan and the money remains unutilized, the other person can sue the company for injunction. Because you're not allowed to use the money, I can stop you from using it. If the company has taken an ultra vires loan, but it can be assigned to a lawful debt. For that part which can be assigned to the lawful debt, the lender steps into the shoes of the debtor and can recover that money from the company. Now, I know this is actually a little confusing. Anyone wants me to explain any of the points again, I will do it. Bolo. Hello guys. See, I'll explain the main consequences, which is a little difficult. First, if you have taken a loan ultra vires, it's void ab initio, the lender cannot sue you. Okay? If this money is unutilized, If this money is unutilized, the lender can sue the company for injunction. That is, you are not supposed to do it, you are doing it, I stop you from doing. Since the money is unutilized, the lender can sue the company for injunction. That is, you are not supposed to do it, you are doing it, I stop you from doing it. Can sue the company for injunction, that means stop the company from using the money. Okay? Second, if the company has taken a loan and this loan is ultra vires, but this money is used to pay a lawful debt. So, when you have taken the money, you don't have a right to take, but it is used for a lawful debt. The company is out of the picture. It is like the lender is paying the other person. Right? This must be creditor of the company in any form. Lawful debt company is paying. Company does not have a right over this money, but still company is paying this money. So it will be deemed as if the lender is paying to the creditor. So the lender steps into the shoes of the debtor. He becomes the debtor to this creditor. But who was supposed to pay company? Who is paying this lender? He can recover this money from the company. Is this clear? Chaitra or anyone else who had a doubt? Naveel, Pranav, Soumya, Chaitra. I can only see these Prats. I hope it's clear to all of you. Chaitra, anything else? Okay, can I go forward? Doctrine of indoor management. What indoor management says is, as an outsider, you have to, yes, Soumya, it can be recovered. It can be recovered. Now, what this is saying is, indoor management says you have to check whether company can do something or not. How the power was given is not your concern. मतलब क्या, आपको ये देखना है कंपनी जो कर रहा है वो कर सकता है कि नहीं कर सकता है, वो आपको देखना है. बट वो पावर कंपनी को कैसे मिला, वो करने का पावर कंपनी को कैसे मिला, वो आपको नहीं चेक करना है. तो कंपनी जब कुछ कर रही है तो आपको ये देखना है कि कंपनी ये कर सकती है कि नहीं कर सकती है, बट वो पावर कंपनी को कैसे मिला वो आपको नहीं चेक करना है. दिस इज व्हाट इज इंडोर मैनेजमेंट. That means what? If the company is issuing bonds, company can issue bonds with the consent of the shareholder. As an outsider, you have to check whether the company can issue the bonds or not. But you don't have to check whether the shareholder's consent was passed or not. That is indoor management. That is for company. So as an outsider, I have to check whether the company has a right to issue bonds or not. How the right was given is not my concern. You did not pass shareholders approval, you did not take shareholders approval, you did not pass shareholders consent. That's not my concern. As an outsider, I only have to see whether you can do something or not. This is what we mean by indoor management, laid down in the case of Royal British Bank versus Turquoise. In this case, the bank was allowed to issue bonds, but after a certain limit, only with the approval of the shareholders. They never took the approval of the shareholders. Bonds were issued, one person becomes insolvent, Turquoise was appointed as a liquidator, asked the bank to pay the bonds. The bank says, no, I'm not liable to pay because we never took shareholders' consent. Here, the bank cannot refuse to pay. Doesn't matter shareholders' consent was taken or not. As an outsider, I only have to see whether the bank can issue the bonds or not. How the right to issue the bonds was given is not my concern. This is indoor management. But because of this, no, lots of people started misusing this. And because lots of people started misusing this, over the years, in different cases, the court came up with a few lochas. So, what are these lochas? First, when you know something is wrong, how can you claim relief? The directors cannot give a loan without approval of the shareholders. Director gave a loan, but no approval was taken. Company says we will not pay. Hey, you are indoor management. How am I concerned? I am not concerned. This, that. Arey bhai, you are not an outsider. You are an internal person. You know what is going on inside the company. You know consent was never taken. What indoor management? When you already know that there was a discrepancy, when you already know there was a discrepancy, on what grounds are you claiming any relief? So, if you already know there is an irregularity, you cannot claim any relief, right? If you already know there is an irregularity, you cannot claim any relief. Second, negligence. You gave money to the security guard, saying that I was supposed to give the money to the officer of the company. You cannot compare officer with the security guard. Here you are negligent. It was your negligence. You cannot claim any relief. The next one, forgery. We never can forget Hasina Banu. Forgery, even you are innocent. You are not at fault. But forgery is a nullity. And however innocent you might be, you cannot claim any relief. If we know a particular person would have what authority to do what work, and it's very evident he is doing something which is not his authority, like an accountant selling the property of the company. You are just an accountant, and it's very obvious he's just an accountant. He cannot sell the property. Can you claim any relief? No. Oh, I don't know the MOA. Leave this time. Next time, I will read. Excuse me. How can you say that? It's your duty to know the MOA. You cannot claim any relief. A person having no knowledge of the articles cannot claim any relief. With this, we are done with this indoor management doctrines. If you have any doubts, please do ask me. Now, moving on to the entrenchment clause. Do you have any doubts, guys? Please ask me before we move forward. My name is Hasina Banu. Rats is missing those dialogues, huh? So, what is entrenchment? The word entrenchment means to provide additional security. The word entrenchment means to provide additional security. This is my articles. If I alter my articles, can I alter my articles? Yes, by passing a special resolution, right? But let us say, no, you should not forget also. But let us say we mention that this clause will be altered only with the consent of, let's say, 90%. This is entrenchment clause. Now, rest of the articles will be altered by special resolution, but this clause will be altered only with I did not know that dialogue will get me so many hearts and flowers, huh, Soumya? So, the rest of the articles can be altered by a special resolution, but this clause can be altered only with the consent of 90%. This is known as what? Entrenchment clause. This is known as what? Entrenchment clause. How can I add this clause? It can be added at the time of incorporation, or if I don't add it, then I can later amend it and add it as an amendment. Generally, amendment of articles needs special resolution. But in case of a private company, in case of private company also amendment needs special resolution. But to add an entrenchment clause, I need consent of all. Whether it is as an amendment or whether it is during incorporation, whatever, the notice of the entrenchment clause has to be given to the registrar. Correct? Now moving forward, share and share capital. Share capital means share means a share in the share in the a share is a share in the share capital of the company and includes stock. When I say types of shares, shares can be what? Equity and preference. When I say share capital, authorized capital, issued capital, subscribed capital, called up capital, paid up capital. Authorized capital is the total amount that a company can raise by the issue of shares. Out of the total shares, whatever is issued capital. Out of this issued capital, whatever portion is subscribed by the public, we call it as subscribed capital. It's not necessary that it has to be fully paid up. So whatever is called up, and on this called up, whatever is paid, that becomes the paid up capital. So let's say called up is 6 rupees per share, company issued 1 lakh shares. So called up will be what? 6 lakhs. Of this, one person holding shares on which 5,000 had to be paid did not pay. So 5,95,000 is paid up capital, calls in arrears is 5,000. And uncalled capital is rupees 4 per share. What are the different types of shares that we have? Equity and preference. What is equity? Which gets what is equity? Which is not preference. What is preference? Which gets preference in, why is it not given? Equity means what? Which is not preference, right? Preference is what? Which get preference in payment of kya? Dividend. And preference in repayment in winding up. That means before the equity, the dividend will be first paid to preference, then equity. In winding up, after the creditors, we will first pay the preference shareholders and then the equity shareholders. Section 44 says, it shall be movable property and transferable. That is why under the Sale of Goods Act, shares are considered as goods under SOGA also. Correct? And it shall be transferable from one person to another. And every share shall be distinguished by a distinctive number. So, on the share certificate top you will see, because there could be 2 Nitika Bachhawat, 4 Nitika Bachhawat holding the shares. Which Nitika Bachhawat I am talking about? So, they have a distinctive number which identifies the holdings of one person from other. Oh my God. With this, I was hoping it will take more than 2 hours to complete, but this actually got completed a little too early. I thought it will go on till 2.5 hours. Anyone wants to ask me anything before we wind up? Anyone wants to ask me anything before we wind up? So entrenchment word means providing additional security. See, if I want to alter my AOA, I can do so by passing a special resolution. What is special resolution? Minimum 75% in favor. Okay? Minimum 75% in favor. But let's say I have put that this clause can be altered only by 90% consent. This is entrenchment clause. The rest of the articles will be altered by special resolution, but this clause can be altered only with the consent of 90%. So it means what? Entrenchment clause makes it more difficult to change. So entrenchment word means something more protective. The articles may contain provision for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures more restrictive. More restrictive means more than 75% are met. More restrictive than those applicable in the case of special. That means more than 75%. So like I say 80%. So the rest of the articles will be altered by special resolution, but this clause will be altered only with the restrictive clause. That means 80, 90, whatever is given. This can be added at the time of formation or later as an amendment. If I add it as an amendment, I need the consent of all the members in case of a private company, or I may pass a special resolution in case of a public company. And the notice of it has to be given to the registrar. Soumya, did you understand or should I explain it again? Keywords. Only these two, as in keywords, as in that it should be there in the answer. Outsiders are deemed to have notice of the internal affairs. It no way means that outsiders are deemed to have notice of internal affairs of the company. Right? If an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the formalities have been observed. वैसे की word specifically नहीं है. This is it. Mainly indoor management is the outsiders are not liable or not obligated to know the internal affairs of the company. That's it. And मतलब मैं आपका क्वेश्चन समझ नहीं पा रही हूँ Prats. What really you are asking me? Are you there? Oh, acha. So the outsiders, no way, internal affairs. You will write, outsiders are not required to know the internal affairs. So not required to know the internal affairs. That is the keyword. That is the keyword. Okay? That is the keyword. Done, guys? So can we end the session here? Can we end the session here? Should I end the session here? If possible, like availability, I need to have this studio room for the session. If the room will be available tomorrow, then I'll keep it tomorrow only. And if not, then day after tomorrow. Okay? I will update you in the Telegram channel. So guys, in that case, I'll wind up the session. I'll see you all tomorrow if possible, otherwise day after, whatever. So till then, thank you. Bye-bye. Take care of yourself. Sleep well, very much needed. If you don't sleep, you'll not have the energy after 2-3 days, and we still have the exams approaching. It's not going. So please take good rest. You need that. Sleep is important. You study, but you sleep and eat properly. Keep yourself hydrated. Keep drinking water because that gives you energy. Every 15-20 minutes, keep drinking water. Okay? Thank you so much. You want negotiable? I've put up a video of revision for negotiable anyway. You still want, then I'll do it. Otherwise, okay? If you want, you just message me. What else you want, I can do it for next 2-3 days. If I can, I'll do it. Okay? So bye bye. Good night. Take care. Bye bye. Bye bye. Bye bye. Message me privately, whatever. Huh?